So these are some frequently asked questions related to the Office of Administrative Law's standards of review for regulations. First, does state law dictate how OAL, again, the Office of Administrative Law, reviews proposed regulations? Yes, when OAL reviews regulations, its review is dictated by the provisions of the California Administrative Procedure Act, the APA, which is contained in California's government code. What does state law provide? The APA sets forth 6 statutory standards by which OAL determines whether a regulation was properly adopted, i.e., whether the rulemaking entity followed the procedural requirements of the APA. What is the authority standard? That basically means that when reviewing whether the proposed regulation states the provision of law which authorizes or requires the proposed regulation. What is the reference standard? It's reviewing whether the proposed regulation cites the law which is being implemented or interpreted. How are these first 2 standards viewed by OAL? So according to them, complying with the authority and reference standards involves a rulemaking agency in 2 activities: picking appropriate authority and reference citations for the note that follows each regulatory section to be printed in the California Code of Regulations, as well as adopting a regulation that is within the scope of their rulemaking power that's been conferred upon that agency. What does the law provide for these first 2 standards? By law, each regulation section printed in the CCR, again, the California Code of Regulations, must have a citation to the specific statutory authority under which it was enacted, and a citation to the specific statute or other provision of law that the regulation is implementing, interpreting, or making specific. If the underlying statute does not expressly or impliedly provide authority for the proposed regulation, then it is void. What's the consistency standard? It's reviewing whether the proposed regulation is in harmony with and not in conflict with other laws. How is this standard viewed by OAL? Their review focuses on whether the proposed regulation is consistent with the other underlying statute. According to the OAL, consistency is viewed as whether the regulation is reasonably designed to aid a statutory objective. It does not conflict with or contradict or, frankly, alter, amend, or restrict any statutory provision. So what's the clarity standard? It means OAL's reviewing whether the proposed regulation is easily understood by those who are affected by it. How is this standard viewed by OAL? According to OAL, regulations are frequently unclear and unnecessarily complex, even when the technical nature of the subject matter is taken into account. They're often confusing to persons who must comply with them. What's the purpose of the clarity standard? The intent of this standard is to ensure that the rulemaking agency drafts its regulation text in plain, straightforward language, avoiding technical terms as much as possible, and using coherent and easily readable language. As such, OAL attempts to ensure that each regulation can be easily understood by those who are regulated by it, and to avoid instances where a regulation is unclear to the regulated community. What's the non-duplication standard? It's reviewing whether the proposed regulation does not serve the same purpose as any other state law or regulation. And how is this standard viewed by OAL? According to OAL, a regulation cannot simply repeat or rephrase a statute. In other words, a regulation cannot serve the same purpose as that of an existing statute or regulation. If it does, there must be some justification in doing so. What's the necessity standard? It's reviewing whether the need for the proposed regulation has been demonstrated by substantial evidence. So what must be submitted to OAL for its review? The rulemaking entity in the executive branch is required to have a complete rulemaking file when it submits their final product to the OAL. That rulemaking file must include all materials and background upon which the proposed regulation is based. And both the initial statement of reasons, called the ISOR, as well as the final statement of reasons, referred to as the FSOR, must be thorough to explain why the provision is reasonably necessary to accomplish the stated purpose of the rulemaking. Is there any limitation on OAL's review of the regulation? Yes, fundamentally, OAL is limited by the APA in its review of the rulemaking proceedings, the record. So it's limited to reviewing the rulemaking file itself. Is there any limitation on a court's review? Yes, a court reviewing a rulemaking will be limited to the documents contained in the rulemaking record.